I have a witness here on Walters that is potentially going to miss a student teacher conference if she has to stay too long. So I'm hoping to get that one going sooner rather than later. So I was wondering if we could possibly bring her up if Mr. Austin's ready, and then go through some. I think we have a couple waivers while we're bringing her up.
That's fine. Okay. And then Mr. Blackman's on Mr. Bell.
Yes. Yep.
All right. So let's bring up Miss Walters, and then let's move some files while we're waiting for that. What did you want to move while waiting for?
We can start with Mr. Bell. I believe that's going to be a waiver.
Okay. All right, so we're on the record in docket 23-03729. That is people of the state of Michigan versus Christopher Bell. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Blackman on behalf of Mr. Bell. He's standing to my right.
And sir, you are Christopher Bell, is that correct?
Yes,
all right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding that this is going to be a waiver of the preliminary exam.
And negotiations are to continue in circuit court.
That is correct, Your Honor.
And Mr. Blackman, is that an accurate statement?
It is, Your Honor.
Okay. I may inquire of your client, Mr. Bell, of his waiver of the prelim.
Yes, sir.
All right, Mr. Bell, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Fred Blackman, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir? It is my understanding it is your wish today to waive your right to a preliminary examination, have this case continue in circuit court where negotiations are to continue between the prosecutor's office and Mr. Blackman. Is your wish today to waive your right to a preliminary examination? Okay. Do the people also waive their right to a preliminary examination?
The people unconditionally waive their right, Your Honor.
All right. I find the preliminary examination be waived to be knowing, voluntarily, and accurately made. And Ms. Wilson, I'll give you the paperwork to have everyone sign it. Thank you. Thank you. Thank you, Mr. Black. All right, I'm in possession of the bind over documentation signed by all parties. I will indicate the exam was waived on today's date, March 8th, 2024. And I will sign the document accordingly. Mr. Bell, your time in district court is done. You'll be bound over to circuit court as charged. With the case to continue in circuit court, you'll get your next circuit court from your attorney, Mr. Blackman. Okay. Anything else for the record in 23-03729? Ms. Wilson.
Nothing from the people.
Mr. Blackman.
I have nothing. Thank you.
All right. Thank you. You're all set, Mr. Bell.
And then if we want to do Mr. Mitz, I believe that's going to be
okay
on the violation.
All right, so we're on the record in docket 23-02581. That's people of the state of Michigan versus Daquan Mitz. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Mitz, who is standing to my right.
And sir, you are Daquan Mitz, is that correct? All right, thank you. This is the time set for a probation violation hearing. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding this is going to be a plea to the violation.
All right. Is that your understanding of Ms. Sutter?
That's correct, Your Honor. We do not intend to contest the violation today, and I would just like to be heard on the recommendation.
All right. Mr. Mitz, my understanding is today you're going to admit to the probation violations. You understand that you can have a hearing in this matter. You understand that the people of the state of Michigan would have to prove that each one of the allegations, you are represented by counsel, Ms. Sutter, today, and she would be present to cross-examine any witnesses or contest any charges brought against you. Do you understand that, sir? Sir. It's your choice today to waive your rights to a hearing and to make an admission on these probation violations. Is that correct? Sure. Have you raised your right hand? Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. It is alleged by Jody Bayless on February 13, 2024, that you technically violated your probation by testing positive for the use of alcohol on January 26, 2024. How do you admit to that technical probation violation?
Is it true that that is a correct violation?
Okay, so you admit to that technical probation violation of testing positive. Okay. It is also indicated that you tested positive on January 28th. You tested positive for alcohol. How do you admit to testing positive for alcohol on January 28th?
If I may just briefly, Your Honor, I believe those have both been submitted as a single violation.
All right.
Collectively.
All right. So I'll treat them as a single violation, but there's two parts to it. And on January 28th, did you test positive for alcohol? Okay. All right. I find the allegation to be admitted of testing positive which is a technical probation violation. And then, Ms. Sutter, did you want to be heard on allocution?
Yes, Your Honor.
You had the opportunity to read the pre-sentence report or the probation violation in pink sheet.
Yes, Mr. Mitz and I did review the recommendation yesterday.
All right, you may proceed.
Thank you, Your Honor. In review of this recommendation from Ms. Bayless with Mr. Mitz, there's not a whole lot that is irregular, unusual with it. She's indicated that Mr. Mitz did speak with her and admit that he had made the unfortunate mistake of having some drinks with his girlfriend, something he knows that he shouldn't have been doing, and he's quite embarrassed about it, particularly in his phone call with me yesterday, that he's hoping to move forward, making better decisions. He is quite proud of the fact that this has been his first issue on probation, and that at the beginning of this case, what he thought he was going to struggle with is marijuana, and that's something he's been able to completely cut from his life, which is something he thought was going to be very, very difficult for him. Given the length of time he's been on probation without any issues, and this being his first and kind of only one thus far, I would ask the court to adopt the recommendation with maybe a minor modification. Ms. Bayless has suggested 1 time a week PBT testing for 90 days. That is a quite costly expense on probation for Mr. Mitz. So I would ask the court to consider, rather than 90 days, perhaps 45 to 60 days to ensure that he's continuing to follow the rules of probation with not drinking. In addition to that, the 12-step meetings, she's indicated once per week. He's not doing those at all right now. And again, alcohol isn't really something that's been a consistent problem in his life. This appears to be perhaps a one-time mistake. So I would ask the court to consider, rather than once per week, perhaps once per month. Other than that, Your Honor, I would ask the court to adopt the recommendation.
Okay. Ms. Wilson.
Thank you, Your Honor. I believe the recommendation is appropriate, but I will leave it to your discretion.
All right. Mr. Mitz, I'm going to treat this as a one-time blip on the radar. I'm going to add some relatively minor I have followed the recommendation. I'm going to hold 1 weekend in abeyance. Okay, so no upfront jail. Follow recommendation. I agree that we'll increase testing for 45 days. as opposed to 90, okay? And then the 12-step meeting, that I don't know that alcohol is a problem here, but there's something controlled substance going on. And so I'm gonna indicate, or could be going on. There's a potential for it, okay? I think it's a fair request that the 12-step meeting be one per month, okay? The verification. I want you to continue with the one per week urinary, the PBT testing or UA testing, just to make sure this is a blip. I think that can be revisited by the probation officer. But you understand what I'm concerned about. I just want to make sure that this isn't something that you're using and continues to be a problem. You can have a productive relationship with this or a destructive relationship with this. You know, we want to make sure that we help you in coming to some good decisions here, okay? With that, I think, as you know, the less we see each other, the better, okay? Yeah, because the more I get to know you, the more your name comes up, the more that I start running out of options. And I want to take care of those options. Ms. Sutter is correct. You've been on probation for some time now. And so let's just get you through this process, okay? Anything else for the record in 2302-581, Ms. Wilson?
Nothing from the people.
Ms. Sutter?
Nothing further.
All right, Mr. Mitz, you're all set. Thank you. And did you want to go on, Ms. Walters?
Yes. Mr. Austin's ready. Yep.
And if we need to break up or stop to get some understanding,
Okay.
you just let me know. All right, so we're on the record in docket 22012888. That is People of the State of Michigan versus Sharita Walters. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Austin.
Thank you, Your Honor, and good morning. Jared Austin appearing today on behalf of Ms. Walters. She is present with me at council table.
And ma'am, you are Sharita Walters, is that correct? Yes. Okay, thank you. This is the time set for a preliminary examination in the matter. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe we're ready to start this exam.
All right. So we will have the usual sequestration of witnesses. So if there's any potential witness in who is going to watch another witness, they should be sequestered. Mr. Austin and Ms. Wilson, you can bring that to my attention. You know the case better than I do. So bring it to my attention and we'll make sure witnesses are sequestered. Ms. Wilson, is there anything else to come to the court's attention prior to starting the preliminary
Not from the
examination?
people, Your Honor.
Mr. Austin.
I just may have one brief second to
Sure.
confer with Ms. Wilson. Just one thing preliminary I would mention, Your Honor, just due to the nature of this case, it's possible, speaking with Ms. Wilson, that there may be some photographs introduced that I think may be rather graphic in nature. So maybe we need to keep that in mind in terms of streaming on YouTube for their community
I do have
standards.
them in paper form, so I don't think it'd be.
All right,
visible
as
on
long as
Zoom.
they just come to the trier fact that they won't be published
Yeah.
on YouTube. And then at any time during the proceeding, pursuant to the sensitivity of the subject matter, if either party just wants to address the live stream, I'm more than happy to hear any arguments on shutting the live stream down. With that understanding, Ms. Wilson, you can call your first witness.
Thank you, Your Honor. The people would call Ann Vanderbos.
All right, Ms. Vanderbos. Can you stand right in front of me? Please state your first name and last name for the record,
Ann Vanderbos,
and then spell them both, please.
ANNVANDERBOS.
All right, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes,
All right, I'm gonna have you have a seat right there in the witness chair. talk into the mic for recording purposes. That'll help us be able to record you. And then please project to the back of the room so we can hear you in general. Ms. Wilson, when you're ready.
Thank you, Your Honor. Ms. Vanderbos, I'd like to just draw your attention back to May 14th of 2022. Is there something from that date that's significant to you?
Yes,
And what is that?
Miss Walters. Staggered me.
Okay, and when you say Miss Walters, did you know Miss Walters prior to this incident?
Yes, I did.
How did you know her?
She lived with my downstairs neighbors.
Okay, so you had seen her around before,
Yes.
so you had a pretty good idea of what she
Yes.
looked like. Do you see her here in the room today?
Yes.
Can you point her out and describe something she's wearing?
No.
Blue, okay, and can you give me a general description of where she's at in the room?
To the ready you.
Okay, Your Honor, for the purposes of preliminary examination, I'd request that the record reflect identification.
Any objection, Mr. Austin, for purposes of,
Without objection.
okay, without objection, the witness has identified the defendant.
And Ms. Vanderbos, if at any time you need a moment, feel free to just let us know, okay? So where did this incident occur?
On my porch.
And what's the physical address of that location?
800 Ramada Drive.
And is
Or
that
not
in
Ramada, Ionia.
Ionia? Okay, and is that in Lansing, Michigan?
Yes, it is.
And is that in Ingham County?
Yes.
Okay. So what were you doing when this all started?
I was having like a little get together. It
Okay.
was just me and one of my friends that were staying with me. We were like drinking, and because it was my birthday weekend, so I was having a friend pull up so we could smoke,
Okay,
and he texted me 5 minutes before.
so when he texted you, were you in the house at that time?
I was in the house.
Okay, and then at some point when you got the text, did you come out of the house?
Yep, I came out the house. He said he was pulling up in 5 minutes, and I just met him downstairs.
Okay, and when you exited the house, was anybody else there?
Yes,
Who was that?
Miss Walters.
Ms. Walters, and where was she?
She was sitting down in the chair.
Okay, did you talk with her at all?
I don't remember that part.
Okay, so moving forward a bit, what happened once you got out of the home?
All I know is I was just standing there by the stairs, and that's all that I remember.
Okay, so was there anybody else around when this happened?
No.
No, just Ms. Walters?
Yes.
Okay, and do you remember anything from the actual assault?
All I remember is that she came up from behind, and I finally got a good look at her, and the words that came out of her mouth.
And what were those?
I'm sick and tired of you white bitches messing with my wife.
Okay, and when she came up behind you, do you know what happened after that?
No.
No, okay, at some point, did you feel like a sensation on your body?
Yes,
What was that?
I was getting stabbed.
Stabbed, and how did that feel?
Not
Not
good.
good.
I was yelling.
Okay, and I know this is kind of a silly question, but you didn't want to be stabbed, right? Okay. At some point during this, did you have to receive medical attention?
Yes,
Okay, and was that at a hospital?
yes.
Okay, and do you know about how long you were in the hospital?
I was in the hospital till my birthday, May 16th.
So about 2 days?
Yeah.
Okay, and after you were released, did you have to have any sort of ongoing medical care?
Yes,
And was that related to the injuries that you had
Yes.
from this? Okay, and what was that like?
it was horrible.
Okay, did you have any sort of ongoing like mental health treatment because of this?
No,
No, okay. So I know we're about 2 years out from when this happened. Are there any lingering effects from this that you're still dealing with today?
with my right arm,
The right arm, and what kind of effects are that?
I could barely do it. Like I could lift stuff, but I can't even hold my kid.
Okay, and when you said that you felt something being struck on your body, do you remember where on your body that was?
It was everywhere.
Everywhere.
Like it's all.
So just for the record, the witness is reflecting like her neck region.
Okay, so she made a motion to indicate that it was her neck and high back.
Ms. Vanderbos, I don't have any more questions for you right now, but Mr. Alston might, okay?
All right, cross-examination, Mr. Austin.
Yes, thank you, Your Honor. Good morning.
Good morning.
So this building you live in, it's not really an apartment building, it's a house, is that correct?
Yes,
Okay. And how many units are there in the house, do you know?
3.
So you lived in one, Miss Walters lived in another one, and then somebody else lived in the third one?
Yes.
Okay. And at the time that this occurred, we're talking about May of 2022, how long have you been living there?
Not even a year.
And so less than a year, had Miss Walters been living there the entire time that you were there? Or did she move in sometime after you, or do you
She
know?
moved in sometime after I did.
You know the approximate time frame when she would have moved in
I-
as it relates to this incident?
I do not. I know she was there before this incident.
And you said you knew her because she was your neighbor, is that right?
Yes,
And by that you mean that you recognized her when you saw her?
yes.
And was she someone that you normally speak to?
I said hi. My kids said hi.
And you really have any conversations with her outside of just kind of exchanging pleasantries?
No, just hi.
And those were pleasant encounters? And prior to this May 14th incident, you had not had any problems with Ms. Walters, correct? Okay. Two of you did not have any negative words exchanged, or no arguments, or anything of that nature? And prior to this May 14th date, you had not seen any type of violent or aggressive behavior from Ms. Walters against you or anyone else, correct? Okay. And prior to this May 14th date, you had no reason to be concerned or in fear of Ms. Walters, is that right? And Ms. Wilson was asking you about a sensation that you felt at some point. You recall her asking you about that? Is that yes?
Yes,
And you had indicated that that was you being stabbed, is that right? And is that because you actually saw the stabbing being inflicted, or are you saying that because of some other reason?
I felt it going like in my skin.
Were you able to see a knife or any type of object while that was happening?
No, I was like I blacked out. I was drinking.
You were drinking that day prior to this?
Yes, it was my birthday weekend.
What had you been drinking?
Wine. I had some tequila.
Roughly know how much of each alcoholic drink you would consume?
Not that much.
Were you able to specify it more than that?
I had 3 shots of tequila and a half a bottle of wine.
And what period of time did that happen as it relates to this incident that we're talking about?
It was right before the incident.
And were there others with you while you were drinking, other friends to help you celebrate your birthday?
I had my roommate with me, but she was upstairs.
Okay. And at the time you felt this sensation that you believed to be stabbing, was anybody with you or around you?
No,
And were you inside or outside the building while that was occurring?
I was outside when I got stabbed.
I think you said you initially saw Miss Walters sitting on a chair, is that right?
Yes.
Is that some type of chair on a porch that we're talking
On a
about? or-
porch.
Okay. And other than what you've already told us and described, you can't really remember anything else about the incident other than what you've already told us. Is that
And
correct?
with my, I had my friend pull up and he got her off of me.
Well, I'm not asking you about what someone else may have told you. I'm just asking about your own
Yeah,
memory and
that's all what I
recollection.
know.
Okay. And that's because you said at some point you just kind of blacked out. and
Yes,
Can't remember what happened after that point.
Yeah.
Okay. The next thing you remember about that, waking up in a hospital or an ambulance?
no, I woke up like when my friend got me up, that's what I remember. And then from that, I passed out in the ambulance.
Okay. And roughly what time of the day was this that we're talking about that this occurred?
I don't remember the time.
Remember if it was morning, afternoon, evening?
Morning, afternoon.
Okay. Thank you very much.
Any redirect, Ms. Wilson?
Briefly, Your Honor. So Mr. Ambrose, you had mentioned that you had been drinking prior to this.
Yes.
So you said that it was right before this incident. Was this over a period of time for the incident, or were all of the drinks consumed like right before the incident?
Yeah, throughout the period of time,
Okay, do you know about how long that was?
maybe an hour or two.
Okay, and now I had asked you about sensations that you were feeling when this occurred. Do you remember thinking anything while this was happening?
I was going to die.
Okay, nothing further, Your Honor.
May this witness be excused from the people,
She may, Your Honor.
from the defense.
Yes, Your Honor.
All right. Ma'am, thank you for your testimony today. You're excused.
Thank you.
Any further proofs at this point, or any further witnesses, Ms. Wilson?
One more, Your Honor. The people called Detective, how do you pronounce your last name?
Moronic,
Moronic, Teresa Moronic.
yes.
Detective Moronic,
That's
you can come up here. And please spell and state your first name and last name and spell them both for the record.
Yes, sir. Teresa, T-H-E-R-E-S-A, Moronic, M-I-R-O-N-I-U-K.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do, sir.
All right, please have a seat.
Yes, sir.
The microphone is for recording purposes, and please project to the back so we can all hear you. Ms. Wilson, when you're ready.
Thank you, Your Honor. Detective Moronic, I'd like to draw your attention back to May of 2022. Were you employed at that time?
Yes,
And where were you employed?
City of Lansing,
And what was your job title?
detective.
And how long had you been in law enforcement at that time?
Asked me to do some math, so approximately 23 years.
Okay, and how long had you been a detective?
Since 2018 of March 2018.
So about 4 years?
Yes.
Okay. And what were your general responsibilities back then?
To follow through on an investigation, make sure I have all the evidence, continue to do interviews with witnesses, make sure if we have any additional evidence that is captured, make sure that tagged in properly, anything to do with the investigation.
Now I'd like to draw your attention more specifically to May 14th of 2022.
Yes, ma'am.
Were you working on that date?
I was, ma'am.
And were you assigned to anything?
Yes,
What were you assigned to?
to a stabbing that occurred at 800 Ionia Street.
Okay, and what was your role in that investigation?
The lead detective.
And what kind of procedures did you do within the investigation at that time?
Yes, I was notified by our detective sergeant that a stabbing had occurred and that they were going to bring the defendant to the operations building to be interviewed.
Okay, and who conducted that interview?
I conducted the interview.
Okay, and do you recall who you interviewed?
Yes,
Who was that?
Sharika Walters.
And how did you identify that person?
By her coming to the operations building, by police car.
Okay, and at some point, were you given her name by someone?
Yes,
And who gave you her name?
I believe it was the police officer who had, transported her.
Okay, and were you able to verify that that person was actually Sharita Walters?
Yes,
And how were you able to do that?
by speaking with her and asking, basic information, name, date of birth, where she
Okay.
lived, those type of things.
Okay, now, do you recognize that person, in the courtroom here today?
Yes,
And can you point them out and describe something he's wearing?
yes, she is sitting on the opposite table of you, and she's wearing a blue jumpsuit.
All right, Your Honor, just for the purposes of preliminary exam, after record can reflect identification.
Any objection from the defense?
Not objection.
Okay, without objection, the witness has identified the defendant for purposes of freedom. Ms. Wilson, you may proceed.
Thank you, Your Honor. Now, in your conversation with Ms. Walters, had she been read her Miranda rights?
Yes, I read her Miranda rights.
And did she indicate that she understood them?
Yes,
Did she indicate that she wanted to still talk with you?
yes,
Okay. Now, did you talk about specifically the incident that you were investigating?
yes.
Did you ask Ms. Walters whether she knew the person that had been assaulted?
I did.
And what did she say?
That, during the course of the interview, that it was somebody who lived upstairs.
Okay. And did Ms. Walters say what she was doing around the time of this incident?
She had explained that she was on the porch and she was rolling cigarettes.
Okay. And did Ms. Walters provide any sort of description or narrative of the assault?
Yes.
And what did she say?
That somebody was picking on her, and further described that as the victim, Miss Ann, and I'm sorry, I forget how to pronounce her last name, I apologize. That she had been picking on her, and that she had been locked out of the house a few weeks prior to that. And she believed that that was intentional by that person. Please repeat the question.
Yeah, did she say anything about the actual assault or the incident that you were investigating?
When I had directly asked if she was part of an assault or anything like that, she had denied being part of an assault.
Okay, did you observe her clothing or her body at all?
Yes,
Do you recall if there was any blood on it?
she had a small amount of blood on one of her fingers.
Okay, and did she have a cut near that or any other cuts that you could see?
I would have to refer to my report for that, but I do remember the blood on the hand.
Okay. Your Honor, may I approach with the report
You may.
for recollection refreshment?
Thank you.
For the record, I'm handing Detective Miranek her report. If you don't mind just silently reading it real quick.
Okay.
And if you can't locate it there in the report, that's fine, we can move on.
I'm not located in this. I know there was a couple different subs that were written.
Okay, that's all right. I can move on. So in your interview with Ms. Walters, did you inquire as to whether she had any weapons on her person during that day?
Yes,
And what did she say?
she had knives.
Okay, nothing further for this witness, Your Honor.
Mr. Austin.
Thank you, Your Honor. Morning, Detective.
Good morning, how are you?
I'm well, thanks, and you?
Well, thanks.
And approximately how long did your conversation with Miss Walters last, you know?
I would have to go back to Axon and I could tell you the exact amount of time. I don't want to put a specific number on that without looking.
Safe to say you discussed a number of topics with Miss Walters? Would
Yes.
that be fair to say?
Yes.
Okay. And she mentioned a number of things during her conversation with you. Is that fair to say?
Yes,
And topic of Jehovah's Witnesses came up a lot with her. Is that correct?
that's correct.
And paraphrasing a little bit, but essentially she would talk about the Jehovah's Witnesses being after her or doing bad things to her. Is that correct?
That is correct.
And at one point during your interview, I believe you noted that there was a fly that was buzzing around the room. Is that correct?
Yes,
And Miss Walters fixated on that for a moment. Is that correct?
yes,
And she said something to the effect of, "See, that is Jesus Christ with me," or something along those lines.
yes.
Miss Walters mentioned to you something about a computer called the Oath or something like that.
Yes.
And a lot of the things Miss Walters was saying to you in response to your questions, would you categorize them as nonsensical?
I would say they weren't pertaining to what we were doing there, I guess, if that makes sense. I don't really want to use that word without having a type of degree in psychology. Or something like that.
From your perspective, a lot of the things you were saying didn't appear to be grounded in reality. Would that be a fair statement?
I would say that was a fair statement.
And what was Miss Walters' overall demeanor like? Was she calm? Was she agitated? Was she yelling? Was she talking in a normal tone?
She was cordial. She was talking in normal tone.
She didn't appear to be nervous.
I don't recall that, no.
She didn't appear to be overly agitated or upset.
No.
Thank you, Your Honor. I have no further questions. Thank you, Mr. Austin. Any redirect, Ms. Wilson?
None, Your Honor, thank you.
May this witness be excused from the
You
people,
may, Your Honor.
from the defense.
Yes, Your Honor.
All right. Thank you for your appearance today. Your You no longer need it for your testimony.
Makes no longer need, okay. Thank you.
You're dismissed from the stand.
I appreciate it, sir.
Any further proofs, Ms. Wilson?
None, Your Honor.
Oh, did you have any pictures you wanted?
At this time, if defense is willing to stipulate to them, I would, but if not, then I don't think so.
All right, Mr. Austin.
I would first need to see which ones they plan on introducing before I could answer that. Objections of that. I guess. It's foundationally, I don't.
So you're going to be admitting them? Okay. I believe you stipulated to
Yes,
these two exhibits.
All
And
right,
for the record, Your Honor, I reviewed those two photographs. I'm not
Oh.
objecting to them foundationally. I mean, I think the people could call the requisite witnesses they need to lay the foundation and admit them. So for the
Right.
purposes of this hearing, I'm not going to require them to do so.
all right, thank you. So I'll have these marked as People's Exhibits 1 and 2.
Matter which way?
I don't think it matters. Thank you. And pursuant to stipulation, the exhibits 1 and 2 are admitted into evidence. Any further proofs, Ms. Wilson?
None, Your Honor. Full rest.
Mr. Austin, any proofs today?
We'll be relying on the evidence presented, Your Honor.
Thank you. Motion for bind over, Ms. Wilson.
Thank you, Your Honor. Today, the defendant, Ms. Sharita Walters, has been charged with assault with intent to murder. Today you heard testimony from the victim, Ann Vanderboos. She testified that this occurred at her residence in Lansing, Michigan, Ingham County, and that this occurred on May 14th of 2022. Ms. Vanderboos identified Ms. Walters as her attacker on that date. She indicated that Ms. Walters, without provocation, had stabbed her in the neck. She indicated that she thought she was going to die during the assault, and she also stated that her friend had to get Miss Walters off of her when he approached. Detective Miranag today testified that she interviewed Miss Walters shortly after the assault. Miss Walters told the detective that she knew of Miss Vanderboos previously. Additionally, Miss Walters stated that she had a knife with her on that date. Intent to murder may be inferred from the circumstances, and it can be inferred in this case, given the weapon, which was a knife, and that Miss Walters stabbed Miss Vanderboos in the neck. And for these reasons, the people assert that the burden of probable cause has been met in this case, and we respectfully request bind over on the charges in the complaint.
Thank you, Ms. Wilson. Response, Mr. Austin.
Thank you, Your Honor. Obviously, the court is well acquainted with the burden of proof at this stage, which is quite low. But just a few things to mention on that, Your Honor. It's certainly troubling, I think, some of the statements and interactions of Ms. Walters with the detective in this case. Certainly, I think would give some concerns, maybe as it relates to mens rea that'll likely be the subject matter of either motion practice or potential defenses at circuit court. I understand that. But I think the testimony that Ms. Vanderboos was able to give was quite limited. I think she was doing her best to remember, but as she stated, she blacks out and she can only remember certain things. So she talked about some sensations that she felt. She didn't really see the weapon, so I think she's doing her best to recall that. But I would just argue, Your Honor, I'm not sure that the testimony that has been presented here today would be sufficient to support the charge that she's currently charged with. I think if there is to be a bind over, I would ask the court to consider on something lesser, such as great bodily harm. Given that, Your Honor, I have no further comment. Thank you.
Thank you. Any response, Ms. Wilson?
Thank you, Your Honor. I would just say that the intent element is largely a matter of fact. That's part of the provenance of the jury. So I would request, again, bind over on the charges and the complaint. I think from the testimony here today and also the exhibits that have been admitted, there was some fairly extensive damage here that was done that is evidentiary of intent. And so I would request bind over.
Thank you. The court's standard, as counsel indicated, is probable cause. They find that the date of May 14, 2022, ID has been made by both Ms. Vanderboss and the detective who testified, 2 witnesses and 2 exhibits. However, the majority of the testimony was majority of the evidence was testimony in regards to this bind over request. Venue has been made in the city of Lansing. Location for 800 West Ionia Street, City of Lansing, Ingham County, was also made by probable cause evidence. And then we come to the elements of the crime. Ms. Vanderboss testified and ID'd the defendant, Ms. Walters, as the person who was responsible, at least the only person who was there, and then said something and was responsible for stabbing her in what she indicated was the higher end of the neck down to the top end of the back. Which is a fairly vulnerable part. She indicated that she then blacked out, and there's some indication that she lost consciousness. She indicated without any hesitation that she did not want to be stabbed, that the stabbing or the intrusive element caused her a great amount of pain. She felt that immediately on the top, that she was on the porch with the defendant when the defendant came up, said something, and then in her words, indicated she felt something slide along or come in to her top neck area. So she doesn't have a memory of everything that happened, but she certainly remembered that in some of the celebration. She had been drinking before, she indicated on cross-examination, and she indicated that when she was stabbed, she was on the porch. The detective, LPD detective, Detective Moronic, then testified that Ms. Walters pretty much placed herself at the scene at the time then she indicated that she denied any wrongdoing in the event and that she was distracted or otherwise distracted by some other issues during the conversation. I have 2 exhibits. One is just indicative of where she was stabbed, and then the other one is concerning the treatment indication. I find at a probable cause level that location, offense, venue, ID, and date has been proven with the assault with intent to murder, that Ms. Walters was responsible for an assault and offensive touching of another, that is being Ann Vanderboos, with the intent to the crime of murder. I indicate murder as opposed to GBH because of the location of the stab wound, which seems to be on her back, going downward towards her chest area. So that is the probable cause level finding that the stab wound. Ms. Vanderboos indicated that, and there's something there's some confirmation of that on the photographs, but it's really based on Ms. Vanderboos' testimony of being stabbed in the back, upper region of the back, by her own testimony. So I will grant the motion for bind over. As charged. So Ms. Walters, your time in district court is done. You'll be in circuit court now with the bind over, and you'll get your next date from your attorney, Mr. Austin. Anything else for the record in 22-01288, Ms. Wilson?
Nothing from the people.
Mr. Austin?
Nothing additional on behalf of Ms. Walters, Your Honor.
All
Thank
right,
you.
thank you. And then I will sign the paperwork to that effect. Thank you for your time.
Perfect. Thank you, Your Honor.
Judge.
And then you can have your exhibits back,
Oh, thank you.
Ms. Wilson, or they'll get, I'm afraid they'll get lost.
I could have a transcript request, Your Honor. Request form.
Oh, yeah.
Transfer, yeah,
Transcript request before you leave.
this is
I don't
Mr.
think
Delay.
it's I'll help out. See if you see your.
So that's Mr. Delay.
Great.
So,
Wendy says
So I didn't- as soon as I have that, I saw it.
oh, and then Ms. Ross, give Mr. LeBrecq too.
Yes, he's here in the courtroom.
No, no,
Oh, that's your.
Wow.
Okay, perfect. All right, thank you so much. Yeah.
All right.
I
Go on,
believe
Mr. LeBrecq.
Mr. LeBrecq, yeah, okay.
Mr. LeBrecq,
Yeah.
right here.
Yeah, you can pull out.
You can come up here, Mr. LeBrecq. And
He's struggling to get through there. Hey, Nathaniel. There we go.
Yep, and away with county.
Yep.
As far as that
I didn't,
I
but I had nothing to get it from
Oh,
the court
okay.
file, so I reviewed it from the court file. But
Okay.
it wasn't sent to me like it normally.
Yeah, I didn't get one there. Yeah. How'd it go? She got over. Okay. How's it doing? Oh, there we go. Yeah. she- Yeah, well, I think I'm good. Um, You get like a full day. I just have one more exam. Oh, no, wait. Okay. I don't have some issues. I'm like your company. Oh, thank you. I walk, so. Oh, then, you probably want my card then. Also, you know, it's truly. Oh, thank you, yes. My guideline, so.
Hey,
all right, so we're on the record in 23-02686. That is People of the State of Michigan versus Alfred LeBrecq. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson, people.
Mr. Austin,
Good morning, Your Honor. Jared Austin appearing on behalf of Mr. LeBrecq. He is standing present to my right.
and sir, you are Alfred LeBrecq, is that correct?
Yep.
All right, this is the time set for sentencing in the matter. Ms. Wilson, is there any restitution on this case?
I don't believe so, Your Honor. Let me double check.
I don't have any, but I was just,
Yeah.
but I don't see any. Mr. Austin, did you have the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor. It was not sent to me as is the normal custom, but the court staff did provide me a copy from the court file this morning, and I reviewed that with Mr. LeBrecq.
All right, perfect. I don't know why it wouldn't be sent to you.
Things happen, so.
Yeah, so,
Rather brief in nature, so it wasn't a big problem.
all right. Any additions, deletions, or corrections?
No, Your Honor, no factual corrections.
Allocution, Mr. Austin.
Yes, thank you, Your Honor. I did an eye chat on Mr. LeBrecq. I did not see anything on there other than this case, so any criminal history he has is rather limited. He has been released since his pre-sentence interview. There hasn't been any issues or problems or violations that I'm aware of. He tells me that he's been keeping up with his reporting duties to who he's supposed to report to. Just a couple things to touch on the recommendation, Your Honor. I know there was the probation department's position that Mr. LeBrecq was not a good fit for probation and that he is denying any wrongdoing. I don't think this is a matter, Your Honor, of Mr. LeBrecq just refusing to accept accountability. I think the evidence is clear from what the court reviewed when the court accepted the no contest plea that this occurred. I think Mr. LeBrecq is likely being honest when he doesn't have memory of this happening. So I don't think it's his just not wanting to be accountable for what happened. There was some delays in this case while Mr. LeBrecq was seeking out screening for various specialty treatment courts. He was initially screened for mental health court, which they did not believe that he was a good fit, but they indicated that he had a substance abuse problem and the drug court would be more appropriate for him. He was screened for drug court and they did determine that he would be eligible and an appropriate fit for that specialty treatment court. The only issue is that they were in capacity and they currently didn't have any room for him. So there does seem to be, I think, a legitimate substance abuse issue, or at least that was largely at play in this case, which I think will likely help explain what happened in Mr. Breck's statements regarding the event or his lack of memory of the event. So I would ask the court to take that into consideration and consider placing Mr. LeBrecq on a term of probation. I think there are some rehabilitative goals to be addressed, and I think he is certainly someone who is capable of being rehabilitated and can benefit from the structure and programming that probation could offer him. If the court is inclined to agree with the probation department's assessment of things, I do think the year in jail that they're recommending is far more than what is needed. If the court is inclined to not place him on probation and just to impose a term of incarceration, I would ask the court to consider time served. He does have a significant amount of jail credit already. Or if the court feels any additional incarceration is warranted, I would ask the court for no more than 6 months. Thank you.
Thank you. Ms. Wilson, any response concerning the allocution of this case?
I would leave it to Your Honor's discretion.
All right. Well, Mr. LeBrecq, do you have anything to say to the court before the court passes sentencing? Mr. Austin has spoken eloquently on your behalf.
Yes.
Do you have anything you want to say in addition to that?
Not really.
All right, thank you. This case has somewhat of a winding road here. And part of probation is, I don't know if I'm doing any favors by placing on probation. It's really somewhat in context as to some mental health concern and some substance abuse concern at this point in time. And I take Mr. Austin, I believe that that you don't have a memory of this, so it's hard for you to admit to this because you don't have a memory. But there's an indication, and a fairly good indication, that you were setting fires that night and there were more than one fire set. All right. That's other things about setting fires at your girlfriend's house were indicated by yourself. So I think Mr. Han is a fairly flexible probation agent in that he sees that probation is not a term for you. And I have to agree, right? I do agree with Mr. Austin's indication that there is an amount of jail time to be indicated. And so I will state for the record that I'm going to sentence you to, based on the no contest plea, the plea of no contest on January 5th, 2024. That was a plea of no contest that you are ordered to spend 180 days in jail. Beginning today. That's beginning March 8th. Credit is given for the 128 days previously served. Going to waive any fines and costs. There's a crime victims' right fee of, well, I'll waive the state minimum cost fee. I think I can waive that, and therefore I can waive the crime victims' rights fee, since it's not a second. It's only a first offense. It's only one assessment. So if I'm waiving the state cost fee, I'll also waive the crime victims' rights fee in this matter. So I've waived fines and costs, crime victims' rights, and state minimum cost fee there's no restitution on the matter, for a total of $0. And sends you to 180 days in jail with 128 days previously served. Any questions concerning the the judgment of sentence, Mr. Austin?
No, Your Honor.
Ms. Wilson?
None, Your Honor, thank you.
All right, good luck to you, Mr. Lebrecq. You're all set.
Good for me.
All right.
I think we're all set, Mr. Austin.
Good day, Judge.
You too.
What was going on with all the motion?
There's some arraignment and then somebody else with a no contact order
Oh,
that's coming in, so I'm not sure.
okay,
But I didn't want my court officer in two places at once.
right.
Just helping out
Oh,
with that situation, so
Thank you.
I no longer seen myself needed. to-
Okay, good.
Yeah. Are you ready for this?
Yeah.
Okay.
One 128.
Just pop on the tree.
Oh, yeah.
Mr. Palmer, are you ready on Mr. McGriff?
Oh, Mr. McGriff is at 11, Judge. He's the one that we
Oh,
moved
okay.
back, but I am ready on Mr. Perkins.
Mr. Perkins. And Mr. Perkins is a probation violation.
Sentencing.
Right, Mr. McGriff was the prelim we went.
That's correct,
Yes.
Judge. We're going to continue his prelim. He was also scheduled for sentencing today,
All right,
That's gotten moved.
but
to
it got
11.
moved. Yeah, exactly.
all right. All right, so we're on the record. In docket 23-03733, that's people of the state of Michigan versus Zachary Perkins. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And thank
Mr.
you,
Palmer.
thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Perkins, who's standing to my right.
And sir, you are Zachary Perkins?
Yes.
All right, thank you. This time set for sentencing in the matter. Ms. Wilson, is there any restitution on this matter?
There is not, Your Honor.
All right. Mr. Palmer, did you have the opportunity to go through the pre-sentence report with your client?
I have, Your Honor. I just have one very brief correction, and then obviously I have comments about some of the
Right.
things that are recommended. My comment or my correction is under the employment data. This was true at the time that the interview was given. But under employment, it indicates he was working part-time at Speedway and also part-time at Meyer Warehouse. He is now working full-time at Meyer Warehouse and no longer working at Speedway.
Right, I've made that update to that section. Mr. Palmer, allocution.
Thank you, Your Honor. I am asking that the court follow the recommendation and place Mr. Perkins on a term of probation with the suppressed status, as this is his first offense for domestic violence. In reviewing the PSI, Judge, I do have some issues with the probation officer's sort of allocution about the case. And what I would say is this, that the probation officer makes a big deal about the fact that she reviewed each of the accounts, I guess, or the use, I think she calls it I reviewed each account of force detailed in the police report and the defendant denied the assaults. A couple of things. First of all, as we know, police reports themselves are not admissible in court, and that is because they at times contain factual errors. I also want to point out that Mr. Perkins did come before this court. He admitted he took responsibility for his actions and he entered a plea. He is not trying to suggest that nothing happened. That's not at all the case. He is simply denying, and from the very beginning, Mr. Perkins said there were some things that happened, but it was nowhere near what sort of the escalation of things that were contained in the police report. And so I believe, because I've seen this happen quite a few times before, I believe that what happened here, and it was confirmed by my conversations with Mr. Perkins, that he was not denying any responsibility. He was denying that some of the things that were, when they read the police report to him and they say, tell me what this is about, and he says that didn't happen, then he gets dinged for denying it in the PSI. I'm just pointing out, Your Honor, that Mr. Perkins has taken responsibility. He's not trying to shrug that responsibility. And so I am making that comment regarding that. The other thing, Judge, I guess I would say is that the PSI is a little bit confusing in that in the written portion of the probation agent's report, she recommends that that defendant have a GPS tether. Then in the, I guess the recommendation sheet it's called, she's recommending a scram tether. And I'm not sure that there's really a basis for either of those things. This is the first offense of any kind for Mr. Perkins. He showed up to court when he was scheduled to. He showed up to his PSI interview when he was scheduled to. He's here today. He has taken responsibility. There's no allegations of any kind of bond violation, whether that be violations of the no contact order, violations of, using controlled substances. There's nothing of that sort here. This is not, I don't know why we need to start monitoring a person who's not had any violations previously. I just don't see the point in that. That's an extra expense for Mr. Perkins and those kinds of things. The last thing I would say is, if the court recalls, at the time of the plea taking, the complaining witness in this matter, Aaliyah Campbell, showed up and asked the court to remove the no contact order. And the court indicated at that time that it would consider that, and that it was going to hold that request in abeyance to see if there was any violations or problems between the date of the plea and the date of the sentencing. Obviously, we are here today. My understanding is Ms. Campbell is not here, but nonetheless, we would renew that request. Part of the reason for that request, Your Honor, is that my understanding is that Ms. Campbell is pregnant with Mr. Perkins's first child. That child is due in May. And so I believe that Mr. Perkins would like to be there for the birth of his first child. He would like to be there to support Ms. Campbell. I would ask or renew my request from the date of the plea taking that peaceful contact be allowed. With all that said, Your Honor, I'm asking the court follow the recommendation to place Mr. Perkins on a suppressed status of probation.
Thank you. Ms. Wilson, anything in regards to, I see the victim was mailed for victim notification as I indicated, once she made the statement to lift the no contact order, and then no statements were made. Do you have any follow-up on that?
I don't, Your Honor. I know that she was here last time and did request that the no contact be lifted. I'm wondering if maybe there was a change in, because I believe they were living in a hotel at one point. So I'm wondering if maybe there was a change in address and communication. But nevertheless, I do recall her being here previously and requesting the no contact to be lifted. So I would leave that to Your Honor's discretion. As for the tether, we've run into this issue a few times, and I think it's largely a issue with the way the recommendation sheet is prepared. My interpretation is that it's not being a recommendation for a scram tether. That's just the only place that a tether location is on the sheet. It's a recommendation for a tether and then a colon with GPS. So I think it's just a GPS tether, not a scram tether. Again, I think that's just kind of a fault with the way that the sheet's prepared. As far as the tether, I don't believe Mr. Perkins is on a tether right now. As far as I know, there hasn't been any violations. So again, I would leave that to Your Honor's discretion. As to, I believe Mr. Plummer mentioned some PBD testing. For my review of the report, there's no alcohol or substance abuse that was alleged in this incident. So again, I would leave that to Your Honor's discretion.
And I can see as part of the assessment, and I agreed, alcohol was not a part of the factual basis or the report, and that it is self-reporting, but it does appear that substance abuse is not at issue in this. So let's first consider. So I'm not going to consider as a part of our probationary measure that testing for alcohol be associated. I just don't see that. I do have concerns about lifting no contact order because I don't have the victim present. I know the victim indicated previously, but that puts the court in a strange position because I don't know what's happened since then. I understand that there's maybe a new child involved. Ms. Campbell really has to contact probation in order to put something in writing so that there's an indication that circumstances haven't changed in some way.
So I guess, Your Honor, if Ms. Campbell provides a written.
Yeah, if I get an indication from a probation department where they forward me something in writing that she's placed, I'll feel better at it. All I have is that the date of plea, she wanted no contact order, and then nobody hears from her. Probation doesn't hear from her, and we don't have a letter from her, and they reach out to her, but she somewhat may be a change of address. So I just want an update on that. So I'll indicate that this judgment of sentence is for a plea. It's taken on January 5th, 2024. January 25th, 2024. Was a plea to domestic violence. I'm going to indicate that there'll be no upfront jail in the matter. So credits given for 3 days previously served, and then the remainder is suspended. 90 days suspended upon completion of probation. I'm going to indicate that fines and costs. We'll do $200 fines, $200 costs. Crime victims' rights fee of $75. State minimum cost fee of $50. We have no restitution on the matter. So a total of $525. Probation is for, as indicated, 13 months by Zoom. I am granting the 769 4A status which is really the carrot here. I mean, if you successfully complete probation, 769-4A is granted, and that's some indication, because this is the first offense, that it's not abstracted in any way. All right. So, I mean, I am at this time, until I hear differently from probation, I'm going to indicate no contact with victim, no assaultive or threatening behavior. I'm going to order no possession of alcohol, marijuana, controlled substance, unless you file a medical marijuana crime with the court, and then I'll grant based on that. I'll treat that as a prescription. Okay. I'm not going to order submission to random PBTs and or urinalysis. I just don't see it as a thing here. I am going to say no bars or nightclubs, because it's a bad place to be on probation, as a bar or nightclub.
I don't even go to nightclubs.
All right, I assume based on your statement, I'm going to order, which it doesn't seem to be ordered, but I do think that a domestic abuse program should be completed by the defendant in regards to some of the things that happen here. And I think the domestic abuse program can be helpful, not only in regards to this situation here, but in regards to any situation you're in order for the de-escalation of it. All right. I think you unfortunately are learning that the hard way. Okay. No purchase or possession of firearms, ammunition, of weapons or any kind. I'm going to have you obtain and keep your employment. You're working full time at Meyer Warehouse. You should keep that. And then I'll indicate for the order that will entertain a probation modification as to the no contact order. I'm gonna order the GPS at this point in time. I'm gonna order it for I don't see GPS on here. I'll write it in there. Will entertain probation modification and no contact with victim. I just need to hear from her to hear that. And I will order a GPS victim or zone no contact. And that'll be ordered for the first 12 sessions of, she says, the BIP program.
I think that's Betters Intervention.
Okay, so that would be the domestic abuse.
Judge, I guess my question would be, with regards to the GPS tether request or condition, if we're concerned that Ms. Campbell has changed her address and her contact information, how are we going to put an exclusion zone on that? In other words, where
wouldn't we we'd put a no contact order in regards to her?
And then, all right, so there's no exclusion. He has to wear the tether, but there's no exclusion zone. It's just purely for tracking.
It'd be purely for tracking and no contact to her. And then if we don't know where she is, we have a problem with that, which tends to be, that's not the first time that this happened.
Right.
So then it becomes a tracker on some level.
Got it.
And if she reports to me that she's able to be, that the no contact should be lifted, so Mr. Perkins can be a part of the newborn activity, then we'll modify or completely take away the GPS because that lifts the no contact.
Right. All right.
So
that's what I was getting.
Yeah.
Thank you, Judge.
So if I hear from her and everything's good in writing, it's got to be in writing because it's got to come to probation so that that's a request to be lifted. I just don't have an update. So I know at date of plea, she came and spoke, but I have nothing since then. I'm willing to lift the no contact order and in essence, lift the GPS. That would still keep you under assignment for the batterer's intervention program. Okay, you'd still have to complete that. And a violation of that would start this bench warrant process over again. And that's what you want to avoid while you're on your 13-month probation, okay? But if I get any notification, so I'll indicate notification to lift no contact may lift GPS. So I think in order to be safe, go down and check in with probation. They'll have all this in and explain to them, you understand the no contact order. This is really to protect you. Okay. So the no contact order is still in place. And then once there's some type of verification of a no contact order to be lifted from the victim, and I'd wait for that to happen. So keep in contact with your probation order, then it's lifted, then the GPS may be lifted. And so there's no ambiguity. Until you get all that from the probation officer, make sure that you stay in no contact, because then there's going to be a probation violation. We want to avoid all that. All right. So yeah, keep in contact with the probation, right? Anything else for the record in 2303-733, Ms. Wilson?
Nothing from the people.
Mr. Palmer?
Nothing further.
All right. Good luck to you, Mr. Perkins. Okay.
Thank you.
Yeah, see what she wants. Yeah.
I think we're-
Got like an hour or so.
So hopefully I'll be back.
All right. Is this the one?
I have to change his bond.
He does not have it.
Both of these are part of his probation
Yeah, that'll be new.
order.
Right.
What are you doing? Nothing.
Nobody's ever said you
What
don't.
happened? Yeah.
And then you need to talk to other people.
And then I think we're ready on Mr. Vallejo.
Vallejo.
Do you have a victim impact statement in your file?
And then Mr. Palmer, you'll be back on Mr. McGriff.
Yes, sir. I am going down to run two, probably going to be somewhat wild prelims in Judge Ward's court with the same client, but
Okay.
I'll be back as quickly as.
All right, we know where to find you.
Yes, sir. I'm not leaving the building.
Yeah. As long as I get it at some point.
Okay.
I don't see a
Okay.
victim impact statement,
Is it okay if I send it to Mr. Neves and
but it's addressed in the pre-sentence report.
do we have a pre-sentence report? I don't have one.
All right. So let's take some time.
Yeah.
I do have a pre-sentence report, and then I have with respect to the victim impact statement. Yeah, I have, and then incarcerations. So there's a recommendation, but so I'll put, but I don't have, I think it's referred to, but I don't have, I did not see a victim impact statement when I previously looked at it. She may be, here it is.
She is not here today.
All right, there is a copy of the victim, and I'll put that with you. And then. All right, so here's the victim impact statement and the pre-sentence report. And then we'll take a second to let you.
Thank you. Yeah.
Is Mr. Craig here on PV right now?
Well, it was after whatever was going on. I don't know where he went because I haven't seen him yet. But and I'm not sure how he knew about it. Due to obviously the no contact order and whatnot.
Right.
There's just all sorts of violations going on.
I don't know. He's supposed to be here at 9:30.
Well, he was here, and then after that happened, he walked out with the detective and Lauren Sutter, and then she said he was back in here with him. And I don't see him, so I'll have to check.
All right.
Mr. Pre,
Yeah,
Is he here?
I saw him and then whatever was happening happened and now he's not.
And his indication was that she was in violation of the no contact orders.
well, well, that's what the violation is for him. He came in alleging she had some red things going on outside. Not gonna-
Oh. Get ready for a hearing.
That's what it sounds like, but it won't be today, so all
Yeah.
right.
Judge, you want to
Oh. 24-00405. That's people of the state of Michigan versus Jabriel McGriff. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Griff, who is seated to my right.
And sir, you are Jabriel McGriff, is that correct?
Yes, Your Honor.
All right. This time set for an adjournment from a prelim. Previously testified, we had Mr. Hayes on the stand. There was an officer, Officer Barbanoff, that testified. We had admitted 3 exhibits. I believe Mr. Hayes was going to be called back.
Correct.
All right. Is that your understanding, Ms. Wilson?
It is, Your Honor.
Mr. Palmer.
Yes, Your Honor.
All right.
Sorry, I'm plugging in.
Right. All right, Mr. Hayes, you can come up here.
Before we start taking testimony, there's just one preliminary matter I could address.
Absolutely.
If at the close of proofs today, if we could possibly rule on the P53 violation before moving to a motion for bind over, because whatever happens on the P53 might impact whether there's actually a motion for bind over.
Okay.
Thank you. That's all I have.
All right.
I have no.
All right. All right, Mr. Hayes, I'm gonna remind you, you're still under oath, okay? Please, and then state your name and spell your last name for the record.
John Hayes, Hays.
Okay. All right, have a seat. You're still under oath. Ms. Wilson, were you still going to ask some questions or?
So I think if I have any additional questions, I can address them on redirect. I
Okay.
believe we were going for Mr. Palmer's
Cross-examination.
cross-examination.
All right. All right, Mr. Palmer, you may proceed.
Thank you, Your Honor. And just, I guess, just to clarify, I realize this isn't going to change what we're doing today, but I just renew my objection about Mr. Hayes' testimony, given that he's
Correct.
not listed on the witness list. Morning, sir.
Morning.
Can you please describe for me what your position or role is at JSG?
Yes, I oversee our entire operations, including training, staff supervision, and court testimony.
Okay. And so to be clear, you're not the owner of JSG, is that right?
Partial owner, yes.
Partial owner? All right. And I guess just as a preliminary matter, there was originally in this matter, there was an individual named Chris Davis who was involved in some of the, I guess, the allegations here, I'll put it that way. Do you know Mr. Davis?
I am.
And how is he an employee at JSG?
Correct. He was the one that was on call the night of this violation, which is why he's listed. He's the one that handled the call to dispatch.
All right. And to be clear, he's, well, if you know, he's listed as a witness on this, right?
I do.
All right. You do know that he's listed as a witness?
I do.
All right. And as I understand it, at least, and you may not have knowledge of this, but as I understand it, Mr. Davis was the one that was subpoenaed to testify last week. Is that your understanding as well?
Yes.
All right. So I guess just to start, why is it that you appeared to testify on instead of or in place of Mr. Davis?
The subpoenas are supposed to be issued to the company, JSG Monitoring, or myself. In having conversation with the prosecutor's office, it appears they had a new staff member who did not understand that or know that, and subsequently issued it to the person who had made the call, as they've done before. And Mr. Davis is not qualified really for testimony. It's not his job at our company, therefore I am here.
Okay. And all right, when you say he's not qualified, what exactly does that mean?
He has no training in regards to testimony. That's something that I've always handled. Therefore, the prosecutor's office is aware that the subpoenas are supposed to come to me directly.
Okay. You say he has no training in testimony. Does he have training in the tethers themselves, though?
Yes.
And so from your perspective, he is qualified to operate or monitor tethers. Is that right?
Absolutely.
All right. So why is it that he's not then qualified to testify about his operation of the tether?
Qualified to testify, I guess, is one thing. Specifically, what I'm more referencing is it's not his job. He has other job responsibilities, and one of them is not to testify. Okay. He could testify, but it's not his job duty.
Okay. You understand that there are plenty of people who would testify about things that are not their job to testify.
Correct.
Is that fair to say? Is there any concern as an owner or operator of that business that Mr. Davis was going to say something incorrect or somehow call into question the reliability of the tether?
No.
All right. So it's just that an internal decision was made by JSG that you were going to testify about tethers in general.
Correct. I do all of our testimony.
And I guess to be clear, with regards to Mr. McGriff's case, the facts involved in Mr. McGriff's case, you're looking at reports and those kinds of things after the fact, but you had no direct or firsthand knowledge, for example, of the alleged tamper on February 15th. Is that fair to say?
I review the reports prior to submitting the violation report to, in this case, pretrial services.
Okay.
Additionally, when the defendant did come into our office, I believe quite a bit later, I was in conversation with that office to identify what they found when the device was returned.
Okay. How many tethers at any given point, and if you know, you know, and if you don't, that's fine too. But at any given point, how many tethers are sort of out in the field by JSG?
Nationwide, I would surmise 2,500 plus.
2,500 plus. And I guess to be clear, are you, when you said that you're a partial owner of JSG, is that nationwide company or you're a partial owner, like, for example, of Michigan's chapter or whatever, even region or whatever?
Nationwide, it's based out of Jackson.
Based out of Jackson. All right. So the Jackson, Michigan is the headquarters for the nationwide company.
Correct.
Got it. And so, and there's about roughly, I realize it's an estimate, but roughly 2,500-ish tethers in the field at any given time.
I'd say that's accurate, yes.
How reliable is the technology that is involved in these tethers?
Extremely.
So, for example, do you happen to know an error rate? So, for example, I guess let me back up and ask it this way. At any point, do you have any knowledge about, for example, false positives or malfunctions of the tether?
The GPS in particular, false positive, I believe would more or less relate to alcohol monitoring.
Okay.
If you're referencing a false positive in the fact of a false tamper.
Yeah, I guess that let me clarify that. That was a bad question. Yes, we're talking about a GPS tether here. So for example, in terms of tampers, is there any way, maybe there's not, but is there any way to tell the difference between an actual tamper and somehow the device having some malfunction that would cause, for example, a tamper to report to generate? Is there any way to tell the difference between those?
It's somewhat a loaded question. I can elaborate in the fact of there's different types of tampering. There's a strap tamper, which is not what we're here on. There's a backplate tamper, which is what I am here on. Those are generally the only real tampering of a GPS device physically. And is it for a false positive rate nationwide or from the manufacturer? I can't tell you. I can tell you from doing this for the last 11, 12 years, a couple things. One, technology's come a long way.
Okay.
I can tell you, in my opinion, in the last 2 to 3 years, a false tamper on a GPS, 1 or 2 that were able to be identified, which later on we were able to find was actually a damage to the strap in both cases. The 2 that I can think of where the strap, the fiber optics in it were pulled apart. On a backplate tamper, I have never seen one. I've tested it myself probably north of 50, 60 times to try to recreate it in any way I could. I've never been able to recreate a strap tamper or backplate tamper without intentionally trying to remove the device. So again, I guess the summary, I don't know the nationwide. I can tell you my experience, I've never seen a backplate tamper, a false backplate tamper. And the 2 cases of a strap tamper were able to identify as damage to the device.
Okay. With regards to the backplate tamper, I know you testified about this a little bit last week, but I just wanted to clarify it. So I realize I'm asking this question in very sort of layman's terms, but with regards to a tether, there is a strap that goes around and there's essentially then a box that sits, actually, I realize that you have it in front of you now. That box then sits on the outside. Is that fair to say?
The outside of the strap?
Yeah, it sits on the outside against the ankle, right?
Yeah, so if I remove it, that is correct. You have your strap, you have the device, the casing of the device, and then the back plate itself.
Okay, and tell me how the back plate works. In other words, when we're talking about a back plate tamper, what are we talking about? That tamper is, or the back plate is then being pushed too far away from the leg? Is that what we're saying?
Similar. So really what we have is we have three main pieces for a device. You have the device and the strap, the back plate, and then the tamper clips, which secure it to the device,
okay,
to the leg. When we are placing it on, we are putting the back plate through the straps on the device that I'm holding up.
Okay.
It is then wrapped around the client's leg and squeezed together. When I squeeze it together, the tamper clip, the top one is pushed in, goes down, connects with the bottom one. The function of the back plate is to secure the strap circular to the device. As I explained last time, on the back of the GPS device itself is the compression sensor that the back plate connects to. When I push it in, you hear that sensor go in. When this is affixed, the back plate, and I'm going to hold just the back plate up so you can see, you will see that compression piece. That's what is pushing in on the back plate in that manner. So there's three main pieces. I'm not sure if that answers your underlying question, but the focus of the back plate is to secure the strap around the ankle, which then subsequently allows us to put the tamper clips in, which then holds it together on the client's leg.
And for the record, the witness was using a demonstration model as he talked through each question, and he still has that model with him for demonstrative purposes.
Yeah, that's fair, Judge. Thank you. All right, so I guess if I'm understanding correctly, then so when we're talking about a back plate tamper, what we're talking about is somehow the main unit that sits on the outside, which has, I think you called it a compression switch. Is that right?
I call it compression sensor. Yes.
Compression sensor. That compression sensor, which sits on that main unit, has somehow moved away from the back plate far enough that it kind of pops out. And that popping out is what causes or triggers the tamper alert. Is that correct?
Exactly correct.
And is that compression sensor, is that spring loaded or how does that work?
I'm not sure what's on the inside of it. I would surmise it's loaded some way, but I'm not outside my area.
Okay. And do you have those exhibits?
Yes.
Can I?
The pictures? Or,
Yeah, just the pictures. And these have already,
we entered them. We stipulated and then we entered them through the officer.
Fair. All right. And you said it was I think you called it a pin. Is that right? Is that fair?
Yeah, tamper clip. Yes.
Tamper clip. All right. So, Judge, I am going to approach, if I may, I'm going to approach the witness with what's previously been entered as exhibits 2 and 3.
You may.
And so, Mr. Hayes, I'm just showing you these previous exhibits. I think you've seen these before. When we are talking about this pin, we're talking about this device right here, or this portion right there. Is that right?
Correct. The portion that you're pointing to is the top tamper clip. In my hand, I'm holding what it's supposed to look like compared to the photo. In the photo that you have, this top piece has been removed. Okay. And that's what you're saying. You're saying the top piece, or the top tamper clip with the top portion being removed.
Got it. And is that designed to be removed, or when you receive them, is that all one unit?
It is all, the top piece is one unit.
Okay.
Similar to what I was just holding up. And again, I broke that piece, but I have multiple others obviously for review. So it's supposed to come as one piece. They are not reusable for this exact reason, because they cannot be put back together.
All right. And so that pin then drops into that hole, which is what attaches the front to the back plate. Yes.
Yes.
All right.
Holds it together. It doesn't attach necessarily,
right.
but yes, it holds it together through.
Right.
Yes.
And is that the only piece that holds those two pieces, that front and the back plate together?
You have the bottom piece that then grasps the top, as I'm holding it up, I have the top, my left hand, bottom and the right, you'll see that the grooves interlock inside of that device.
And what are those pins made out of? Is that plastic?
Plastic.
All right. And so in this particular instance, is there any indication that there was a problem? There's 2 pins. Is there any indication that there's a problem with the pin on the bottom, or is it just, at least as far as we can tell, the one on the top?
From what I can tell, it's just the top. The bottom piece can be removed by removing the top piece, pulling it out and pushing through the bottom. So the only piece that is truly damaged in this case would be the top clip. The bottom clip could easily be reinserted through the bottom and nobody would ever know.
Okay. And with regards to the length of the tamper, is there any way to tell, for example, once that's damaged, does it just give a tamper alert?
Yes, so in preparation for today, I did furnish the prosecutor with an alert generation report. In a case like this, that's important to know how our on-call is trained to, not just our on-call, all of our staff is trained to supervise these cases. When we get a backplate tamper, what we will do as a safeguard is we will clear that alert once we receive it, and then see if that alert comes back. Okay, if that alert comes back, that tells me that that back button is still not compressed, meaning it's not together. If that backplate tamper comes back or does not come back, that tells me that it then has a good connection. In this case, our staff cleared the tamper. It then returned, telling me that it still was not back together the way it's supposed to. We've had cases before where we have had a backplate tamper did not return. Law enforcement gets out there, finds out that the device is sitting on the counter, right? You can Google how to install these devices. It's then sitting on someone's counter, hoping that we don't take action on it.
Right.
We've had other cases where the backplate tamper comes back right away because they're trying to figure out how to put it back on themselves, or they just don't care. They've removed it and thrown it out the window. So when you see that report and you see that there's a backplate tamper clear, backplate tamper again, that's the reason. So the duration would be however long all of that takes. In certain cases, when it comes back, obviously we're not going to try to clear it again because we've already determined that it's not on the leg.
Sure. And you would, in a situation like this, you would expect, given that that top pin, that tamper pin is broken, you would expect that once it's broken, it's not going to hold together, right?
No, once it is broken, it is easily held back together. I think the last time I was here, I demonstrated what that looks like. And I can do it again. When the bottom pin is in here, even if the bottom pin is in by itself, the top pin is not in, it'll still hold it together. And it's important to note that that's because the way that it's holding that back plate, the pressure on the back plate is coming apart. The pin is in there, so it's holding it together. Like it's almost like vice grips, but reverse vice grips. It's holding the inside of it together.
But I guess what I'm getting at is, so in this particular case, the one we're talking about, we've seen that sort of the top or that L piece that sticks off that tamper pin was broken. We've seen that, right?
Yes.
And so once that piece was broken, that caused then the top tamper pin to start, not a lot, but to start to rise up out of the base. Is that fair to say?
I do not agree with that portion. No.
Okay, explain that to me.
Gravity.
Okay.
If the top pin is in, it's all the way in like it's going to be. No matter what you do with that top pin, it's not going to come out unless you dig at it or pull it back out. When that top portion is removed, like I just removed, it's not going to come out when it's on the leg.
Okay.
Even if you go, I mean, I can sit here and slam it against my hand the other way, it's still not going to come out because that pressure, how I referenced the back plate and the GPS, are pulling. It's pulling it apart. There's pressure. Gravity is not going to allow it to go up in any fashion, let alone with that pressure. The only way to get that pin up after removing this is either pulling it up with tools of some sort. I can probably use my fingers, or when this piece came out was because I pulled it. When this piece is removed, if I remove this the way I just did, and I was going to put the pin back in, when I put my finger in, I can't get it flush because the groove is there. The only way to do that is to put this pin and push it all the way flat. In that picture, you can see it's elevated. The device I'm holding in my hand is elevated as well.
Okay. And do you know, for example, I think pressure is measured in pounds per foot or something like that, but do you know, for example, how much pressure, that's a relatively small little piece of plastic, yes?
It is.
How much pressure or force would it take to break that small piece of plastic?
I don't know. I don't have that information. In the device, I've put it together, slammed it on concrete. I've tried a lot of that, but as far as pounds per square foot is, I think, as you referenced, how they measure it, I'm not sure.
That's fair. And I guess I'm almost done here, but the last questions I have for you. So when that pin is placed into, well, let me back up here. There is almost like I get Judge, may I approach the witness? I have exhibits, well, I guess I just really need to. There's almost like a channel here, like is that right? You see that?
Yes.
And within that channel, the top of that pin then sits down into that channel? Is that correct?
If it is installed with the top portion of that pin, it's designed to be flush. Last time I was here, I was trying to pull that pin apart with my nail and was not able to. But yes, that top tamper clip fits flush with the top of the grooves that you're referencing on the GPS.
With the top of the grooves, is there any overhang whatsoever with, for example, on the outside? I'm not talking about the top of the device. I'm not talking about the side of the device. If that makes sense. If my question makes sense?
It makes total sense, and I know it's very hard to follow. Inserted properly, it's absolutely impossible.
Okay.
That is fit exactly for that portion. When it is put in there, as I have it here, it's flush. There's no overhang. The only way you can get the top groove or the top pin and the bottom pin to connect, it has to be exactly perfect. When they squeeze it, you can hear the click. It has to be that way. And if it's that way, then no, there's no overhang on the top or bottom. It's flush.
I have no further questions.
Any redirect, Ms. Wilson?
Just briefly, Your Honor, thank you. So, Mr. Hayes, I just want to clarify the kind of the process of how this occurs when you get a tamper alert. So when you get a tamper alert, do you just get an alert that there has been a tamper?
Correct.
And you don't get any alert as to what the tamper is aside from possibly whether it's a back plate or a strap, correct?
Correct. Those are the only two that we get.
Okay, so how do you then obtain information about how the device has been tampered with?
So the first option is we clear the alert as I referenced. If the alert comes back, or if it doesn't, we then attempt contact with the defendant.
Okay.
We're trying to identify, there's cases where they've damaged it. We've had people playing basketball. We've had people drop washers and dryers on them. We give them the benefit of the doubt. Show us what's going on. Tell us what's going on. If it's something that we can identify they're being cooperative, we will then have one of our field installers or field staff try to meet with them immediately to rectify it. If we cannot make contact with the defendant, or if they're inside the victim zone, we contact dispatch. In this case, we attempted contact. We did send dispatch once we were able to identify that the backplate tamper came back. And that's the process that was taken here. And then obviously our on-call staff did speak with LPD.
Okay, and just to clarify, it's when that top piece comes off, that wouldn't trigger a backplate, correct?
You could take just the top piece out. You could take just the bottom piece out. You could pull the pins out individually. It would not remove it. The only way to generate a backplate tamper is to remove both, to where the faceplate and the GPS device are not in contact anymore, generating that alert.
And in this case specifically with that pin being removed, I believe you said, but I want to clarify, it can be reinserted, correct?
Absolutely.
And then it can be put back onto the person's leg?
Yes.
And is that fairly simple?
Yeah, it's very simple. You can watch YouTube videos. The only thing that doesn't account for is the top piece not being able to be reconnected. As I referenced here, and I believe exhibit 1 or 3 has that top clip that cannot be reaffixed.
Okay, I have nothing further for this witness, Your Honor. Do you want me to republish the exhibits?
Sure. May this witness be excused from the people?
You may, Your Honor. Thank you.
From the defense.
Yes, Your Honor. Thank you.
All right, thank you for your appearance today.
Thank you, Your Honor.
Any further proofs on the preliminary examination Ms. Wilson?
Not from not for the exam or the bond violation, Your Honor, and I would just reiterate my request for a ruling on the bond violation first.
All right.
And the people do rest.
And then any proofs today on the preliminary examination, Mr. Palmer?
No proofs from the defense today on the exam,
All
Judge.
right, thank you. Did you want to be heard? So,
I can make a brief argument, Your Honor.
all right,
Yeah.
and so I set the stage here,
Yep.
so we understand. We have a preliminary examination that all proofs are done, which is a probable cause hearing. We have a bond violation, which is the sum and substance of the preliminary examination, which is the tampering. And then we have a sentencing set today on the bond violation, which came out of the attempted RNO.
And the underlying RNO, I believe.
Yeah, right. There was an underlying RNO and then a plea to the attempt RNO.
Correct.
Which is the 1 year.
Mhm.
All right. So I've got all those in a row at the request of the people and without objection. We'll be considering the bond violation first, which is the sum and substance of what the preliminary examination we just heard. So Ms. Wilson.
Thank you, Your Honor. I won't, there's been pretty extensive testimony as to how the tamper works and everything. I won't get too far into it. I just want to highlight a few points here. Mr. Hayes here did come here with extensive experience. He was qualified as an expert previously in the GPS tracking and monitoring devices. He did testify here today as to how the reports are brought to JSG and how they then obtain information as to what happened to create that report. And he did testify here today that police officers in some instances, and is in the instance in this case, go out to the defendant and try to figure out what's going on. He has also demonstrated pretty extensively how the device works, and he has made pretty abundantly clear that it's just not possible for that top piece to come off on accident. He's also explained that that top piece coming off alone would not cause a tamper alert. Now, when the officers responded to Mr. McGriff's home, they did make contact with him. The ankle monitor was on his leg. As Mr. Hayes testified here today, it is fairly simple to get that back on, and they did obtain evidence of that tamper of that top piece, which has been presented as an exhibit to this court. With all of this information kind of coming together, it's pretty clear that this was not an accident, and that tamper device or that device was tampered with, and that there was some kind of either removal of the device wholly or partially, and that it could not have been done by accident. It was done knowingly, it was done intentionally. So for those reasons, I would ask that the court find Mr. McGriff responsible for the bond violation today.
Right, and do you have any indication on sentence on the bond violation? If I was to proceed in that fashion?
If you were to proceed today, Your Honor, I will largely leave it to your discretion. I will just say that this has been kind of an extensive amount of resources that has been provided to get this done today. So I would ask that that just be taken into consideration, Mr. McGriff's inability to take accountability for what has occurred. And again, I'll largely leave it to your discretion, but I would just ask the court take those factors into consideration.
All right, Mr. Palmer response.
Thank you, Your Honor. I'm asking that the court not find guilt for Mr. McGriff regarding the bond violation. And of course, I'm also asking that the court not bind the matter over for lack of probable cause. My main issue in arguing this, at least for the purposes of today, Your Honor, is the following. We heard testimony. Of course, we have to piece the testimony from last week back together with the testimony from this week, but we heard testimony about the device itself. We heard testimony that with regards to the tether itself, that the pins would have to be removed, and that the pins then being removed would cause the backplate tamper, which is essentially the type of tamper we're dealing with here.
Your Honor, I'm just going to object. That's not the record evidence. I believe the record evidence is that the pin removal and then the displacement of the plate is what causes the back plate tamper. It's not the pin removal itself.
We'll let the record stand for itself. This is argument, Mr. Palmer, so you may proceed.
Thank you. Judge, my point here in getting at this, and I understand what the people are saying in that regard, and it's not my intention to try to skew the evidence here, but the testimony is that there was an ongoing tamper, that police were alerted to this tamper, that there was this ongoing tamper, and that according to the expert testimony we've heard, that this tamper was caused when the back plate separates from that main device and I think it was the compression sensor is then activated. In other words, it's no longer compressed, that causes an activation. What we also heard though is that the pins, as I understood the testimony, and it's not my intention to confuse the court or misconstrue it, as I understood the testimony, it was that is caused when the pin is then removed in some way. And that if the pin is reinserted, we have a, that will then, I guess, recompress that sensor and cause that warning to go off. But what we now have is a situation in which we received according to testimony, we received a tether alert or a tamper at approximately, I believe, 4:30 in the morning. It was, police were dispatched to the house. The tether was apparently tried to be reset. And as Mr. Hayes testified, there is a reset of that. And then if the device is still if that sensor is still not depressed, then it'll trigger again. And that's a clear indication that then the tether has been violated. In other words, there's an ongoing violation here. But that conflicts with the testimony that was provided by the officer. The officer that testified last week, whose name I absolutely cannot pronounce, but what is it? Barbanoff. That officer testified that when he appeared on scene, that the tether appeared to him to not be tampered with. He said that there was a very, very small plastic piece. It's the same piece. There's no debate. It's the same piece that Mr. Hayes testified about. But there was this very, very small plastic piece that had been broken off. That piece was provided to that officer, and the officer otherwise took pictures of the device. The officer, who admittedly does not know a lot about tether, admittedly, and he said that, I think, but he said, as far as he could tell, the tether did not appear to be tampered with. The other interesting thing about this is, again, as I say, my understanding, and the court can make its own decision based on the testimony it heard, but as I understood that testimony, if those pins were inserted, or once those pins are inserted, it should not be alerting to a backplate tamper. And yet the photographs that we've introduced as evidence that were taken by the officer who responded to the scene shows that the pins were in the GPS tether, and yet we still have an ongoing tamper alert. So my suggestion to the court is there is not enough evidence here to find him in violation of the bond. I recognize that the court's put in somewhat of a difficult position because the court has to weigh evidence sort of in two different ways. They have to weigh the evidence on the bond violation, also the probable cause standard for the preliminary examination. I understand that there's two different things there. What I would say is that even if the court, first of all, I'm saying that there's not probable cause there. And so the case itself should be dismissed. And then by virtue of that argument, that the bond violation should also be dismissed because of the higher standard. But what I would ask is that even if the court finds that the probable cause standard has been met, there is certainly not enough evidence there to find a bond violation. And I would ask that the court dismiss that bond.
Thank you. Just so we're clear, this is in regards to the bond violation. It is a higher standard than PC. So I'd have any response, at least deal with the standard also.
Just briefly, Your Honor. So just to clarify a few points, it was my understanding from the testimony today was that the clearing of the tamper was not done when the officers were at the residence. It was done immediately after getting the alert. So I don't think that testimony necessarily conflicts with the testimony that we've heard previously. Additionally, it's my understanding that the pins being removed themselves would not necessarily trigger the tamper. It's the removal of that backplate, which is necessary for the pin to be removed, but I don't believe that that's necessarily what was stated. And I will again reiterate, as Mr. Palmer did say in and what in his argument, Officer Barbanoff did testify here today that he's not exactly familiar with tethers. So his indication that he didn't think that the tether was tampered with is not necessarily giving any stronger or lesser credence to Mr. Hayes' testimony as to his interpretation of the evidence and his expertise and his expert opinion into how the tether was tampered with. So again, I would request that that bond violation be found responsible.
All right, I've heard the arguments and the testimony concerning the bond violation. It is, and we've had a direct and a cross examination, and then another direct and a cross on some level with both John Hayes and Officer Barbanoff. And I don't know if I'm saying that correctly, but Mr. Hayes, if he took the stand, answered any questions in regards to the bond violation. The court heard all the evidence. I find a bond violation occurred. I find that the back plate was tampered with. It seems from the testimony that it would take an enormous amount of work to tamper with that. I mean, we're talking multiple pounds of force to even remove the pin, much less get the device open. It just seems like it's not an accident, and there was some indication that it was an accident. This is a device constructed for accidents not to occur. So I find the bond violation has been met for me way beyond probable cause, way beyond preponderance of the evidence. We're getting near beyond a reasonable doubt in my assessment, and of course that's not the standard, but I do believe that a bond violations occurred in this matter. We placed Mr. McGriff on a GPS bond on his attempt to R&O, and now we don't have that. We have a tamper with that, which is concerning because this bond violation occurred while on probation to another Ingham County Circuit case. So hence the bond probation, and we have not even sentenced him on that. So the decision of the court for the bond violation is the defendant is to do 30 days in the Ingham County Jail. In ICJ, I'm going to set the sentencing after that 30-day period of time, because it doesn't make any sense to do the sentencing until the time's done, so that Mr. McGriff is getting any time that he's going to do the 30 days. So he might as well collect on the 30 days before sentencing. So I will assess the sentencing after the 30-day period. So 30 days in the Ingham County Jail, and then the sentence for bond violation for tampering. I am going to set the sentence on the matter past 30 days out, or in that vicinity. So within a month.
April 15th at 1:30.
April 15th at 1:30. So the sentence is 30 days on the bond violation. Sentencing is reset for April 15th at 1:30. And then, so that should do with the sentencing and the probation violation file. Did you want to talk with counsel concerning now the motion for the preliminary examination?
I don't think so. At this time, the people will not be asking for bind over on the felony count of the interfering with the electronic monitoring device, and we'll be requesting a dismissal without prejudice in the interest of justice.
All right. I'm assuming there's no objection to that, Mr. Palmer.
No, none whatsoever, Judge.
All right. So on that matter, on the preliminary examination, the felony case, it's dismissed without prejudice. Without prejudice per the prosecutor's office. And I will sign a nollie-pros once Mr. McGriff is taken to the Ingham County Jail to that effect. Anything else on the record? So this case is dismissed without prejudice pursuant to the felony. Anything else on 24-00405? Ms. Wilson,
Nothing from the people.
Mr. Palmer.
I guess just to clarify, we're resetting the sentencing for the attempt R&O to
Correct.
4:15 at 1:30.
Correct,
Right.
since he should be collecting time on that anyway.
Understood. All right. And, okay, yes, that's fine.
I got a question.
All right, anything else for the record in 24-00405? Ms. Wilson.
Nothing from the people.
So you're gonna, the point is, you're probably going to be out by the time we have to come back.
Okay.
Because he gave you 30 days, but 15th is more than 30 days. See what I'm saying? So I'll put a note and I'll try to keep track and I'll call while you're around.
All right, so keep in contact with your attorney, Mr. Palmer, and any questions on that 24-00405? Mr. Palmer.
I have nothing further.
All right, thank you.
Yeah.